Good afternoon. Firstly, we want to try and motor through this because we are standing between you and lunch. And if I know one thing about this wonderful city, people like their food. So we want to keep motoring through. I have a very distinguished panel. I'm not going to go through their qualifications, but on my immediate left, I have Marina Weiss from Bredin Prat in Paris. I then have Anne Hoffman, who's an independent arbitrator. I then have Sona, and I'm going to massacre the surname for which I apologize, Tsaturyan.
That was pretty good.
In that case, I'm going to stop there. I'm not going to introduce my next member of the panel, whose surname I'm also going to sadly massacre as an Englishman, who is Margarita Adadurova.
That's perfect, thank you.
And then on my immediate far left, I have Sergey Alekhin from ELWI. We're going to be talking to you in the next hour about three topics. One, interim relief, or interim applications. Second, emergency arbitration. And then third, applying that to investor state. But for the first 40 minutes or so, we're going to be talking about commercial arbitration. And just to set the scene, in terms of interim relief, what we're really talking about are situations where you've got an arbitration underway, and one party is concerned that something is going to happen that is going to threaten their ability either to pursue the outcome of the arbitration or to pursue the arbitration itself. So you might be talking about, for example, if it's a arbitration in relation to shares, maybe you find that there's a risk of the shares being transferred during the arbitration. Maybe it's a question of assets present or evidence that needs to be preserved. Maybe it's a question of getting documents or something like that from a third party. So that's the sort of area we're in. And Sonia, would you mind sort of leading off in terms of the sorts of challenges that you face when dealing with interim applications?
Sure, thank you, Julian, very much. And thank you for Amka and to Lilith for this kind invitation. It's a pleasure for the first time not to be in Armenia for visiting my parents, but also for such a cool event. And specifically to challenges dealing with interim relief measures, and I would like to just demarcate the topic in terms of, I'm going to speak about the challenges in the process of applying for interim measures. I will leave the enforcement for now aside. I think when we speak about the challenges, we have to first look into the criteria the tribunal applies most of the time when granting or dismissing the requests. And while we, as all know, most arbitration rules and most national arbitration laws do provide for this power to grant interim reliefs, a lot of them are very salient on the criteria. And this is where the issue arises. And the challenge is twofold. First, as a counsel, you really have to know the seat rule, the national law, because sometimes, in particular in model law countries, you may have some guidance in the national law. And second, you have to look at the practice developed and the criteria developed through the practice. And starting with the first one, recently we're dealing with German-seated arbitration, where the German law is a model law, German arbitration law, and accordingly you need to have an interim relief request which is necessary in respect of the subject matter of the dispute. This is something that you will not find in the English Arbitration Act, which grants more broad discretionary powers when it comes to interim reliefs. And the tribunal interpreted it in a way that you have to have an existing pending claim. It was an ICC arbitration with the terms of reference. You have to have an existing pending claim that needs to be secured with the interim relief that you are seeking. And the party that brought this arbitration, the opposing party, did not have that claim. Even they teased in their application that we are going to set out the claim in full in 10 days. And this is something that when you are in a German-seated arbitration will not simply work. And the second, I talked about the practice-developed criteria when tribunals come to deciding on the interim reliefs. And they sound deceptively simple. We have the risk of irreparable harm, we have urgency, we have prima facie case, proportionality, or as the common lawyers used to say, balance of convenience. But when we come to understanding what is this evidentiary standard that the tribunals at the end of the day apply to grant or to decide on those applications, we see quite a range and array of ways that the tribunals in fact interpret it. For one tribunal we had, urgency was not a self-sufficient criteria at all. It says, as long as I see a risk of irreparable harm, it doesn't matter whether that risk can happen today or in 10 days, I don't need to discuss on urgency. There is a risk that justifies it.
Can I jump in there? Because
Sure.
I think that's a really quite an interesting point, which is about the evidential standard that tribunals apply, including maybe the difference between different common law civilian jurisdictions. And as an arbitrator, what are your thoughts?
Yes, thank you. And I think all of those points are valid. I'm kind of, I don't want to say horrified, but slightly flabbergasted by the arbitrators you have in your cases. No, but more seriously, looking at this from the arbitrator's point of view, of course, you know, what we're looking to and what we're bound by is what the parties are telling us. And so for me, it is extremely important that the parties are setting out what they expect from the arbitrators, one with regard to those criteria that should be applied, which Sona has just referred to, but the other one is with regards to the evidentiary standard. And very often, I find very little on that in submissions. And so then, unless, you know, there's time, and you know, as we know in these kind of proceedings, there isn't, it's then, I don't want to say difficult for the tribunal, but the tribunal is kind of left to its own devices, and that's where some of the problems arise. I find the evidentiary standard particularly challenging, having thought about these criteria when I apply them as an arbitrator. Not so much, interestingly, with regards to the urgency, because to me that is a self-standing criteria, and I think, you know, it matters to me if something can cause harm in a year, then that's not something which should be subject to urgent interim relief. But the standard that's being applied, for example, with regards to the reasonable chance on the merits, which is prima facie, which is also a criteria, and that, you know, fluctuates depending on when in the case the application is raised. And if it's halfway down the line, then that's kind of a little bit more obvious and more easy for the applicant than it is when you're at the very start of the case and you need to still try to tell the arbitrator, well, we have a reasonable chance, without, you know, repeating your entire statement of claim, which may or may not have been filed yet. So there is an interesting challenging issue for me as an arbitrator, and potentially for you as counsel. The other one is also the real risk of imminent harm. You know, where do you set the line? How does this work? And it's generally assumed that it shouldn't just be it shouldn't be compensable with money. And so that's also an interesting point for me as an arbitrator. So those are the challenges. But when it comes to the evidentiary standard, you're absolutely right. I would try and find something which is arbitration specific rather than dependent on national laws, of course, because we all work in international arbitration. But really, note to counsel, please tell me what you expect from me as an arbitrator.
If I just tease out a couple of points there, I mean, I think what we're really hearing there are interesting questions about how do you deal with, well, one, what is it you're being asked to do? At what stage you're being asked to do it? Questions about how do you look at the chances of success on the merits and irreparable harm. Does anyone else have any thoughts on those that would be useful to share?
Thank you, Julian. One very, very quick recap from experience is that when you look at the good case on the merits or the prima facie case on the merits, of course, by definition, you cannot be expected to be delving into or to, as a party, establishing it. However, there are very marking examples, for instance, cases where the relief requested is not legally possible because the national law, and we had a case like that where Swiss distribution law was applicable, and the law did not allow for the relief that was being requested. It simply didn't. And that was a killer argument to be put forward as a respondent to dismiss, and it was in the context of an EA application, because if the relief isn't possible, and if it's a case of binary analysis, yes or no, without delving into evidentiary questions, then you are in the sphere of the obvious, which I think is interestingly exemplifies what interim relief adjudication is about, right? It has to be straightforward on one level or another on this scale.
Can I just ask the panel this question? If you see interim relief applications in at least half of your cases, can you put up your hand? And if you see them in less than half, can you keep them down? I think there's an interesting, it may be a subject for later on, but there may be an interesting question as to whether there's a divide here between civilian and common law jurisdictions. Because certainly my experience is in most commercial cases, and I deal with construction and therefore probably the assets are much more fixable, but I relatively rarely see them. But from a party's perspective, I think what you need to be thinking about, teasing out those points are, one, do you need some sort of interim protection? You know, are your assets that you are chasing after about to be disposed of, is evidence about to be destroyed? Is there something you need? If so, you then need to think about when you make your application. And you do, I mean, this point about is the relief legally permissible is a really important one. Because often as a tribunal, I think you're in a position of dealing with it where you're having to be very careful because you don't want to step into the arena and look as though you're favouring one side or the other, but it's a serious application. In terms of, Sonia.
Maybe just one last remark. I think if we were talking about interim release that are, let's say, justified, then the number would be very low. I think what I do observe is most of the time the council brings the interim relief request as a strategic tactical tool, 1 week before the submission of the opposing party, or to have the first opportunity to plead on the facts. So I think the divide is real in that perspective.
But it is a very useful tool. Another area that we want to touch on briefly is ex parte applications. Because let's just take, you've got a situation where you believe that the other side is just about to sell shares. If they know you're about to make an application, they may actually complete that transaction immediately before you can get. So you want to make an ex parte application. That's always difficult in arbitration because you're not meant to have unilateral communication. There are increasing opportunities to bring those sorts of applications. But I'm interested in this question of how do you balance, therefore, for example, confidentiality, because you're keeping something from one party for due process. Anne, I don't know what your thoughts are. Oh, no, sorry, Marina, hang on. I can't even read my own writing. Marina, I think you were going to lead off on this one.
I mean, I would have said something about, I'm still wondering whether ex parte applications are something that should be in international arbitration at all, but I think that's a philosophical discussion we can then move on to later in the next break.
Marina, sorry to cut you off.
I will address this as well. Because indeed, so let's take a step back. Ex parte applications before national courts are, depending on the jurisdiction, something that is very common and not controversial. In arbitration, as Anne alluded, the idea of ex parte relief is not, one would say, subject to a full consensus. Why? Because you have two potentially conflicting positions. On the one hand, there is the imperative that parties to arbitration must be given the opportunity to present their case, because that is part of what conditions the consent to arbitration, and absent such respect of due process rights, an award can be subject to challenge. And on the other hand, there is a conflicting consideration, which, as Julian said, is that in certain cases, the needs of the case and the preservation of the relief requested requires prompt action, and the purpose would be defeated if the adjudication of such a request were subject to a briefing phase, because then you give the other party the possibility to act and do precisely what you seek them to prevent from doing. And thereby you are jeopardizing the whole finality of this urgent relief that is needed. And so obviously commentators have argued that if in arbitration ex parte or preliminary interim relief measures were categorically excluded, you would deprive arbitration from its full effectiveness, and that cannot be that cannot be within what arbitration is supposed to achieve, and that party consensus should be presumed to exist for those types of cases. So that's, I would say, that the philosophical framework. Now, how do arbitrators deal with this? First thing to look at, of course, are the rules, right? Arbitration rules very rarely explicitly permit ex parte arbitration. What they do is they grant arbitrators broad powers generally to conduct the proceedings as they see fit, subject to respecting due process rights. Arbitration rules do grant the arbitrators the powers to order interim relief. And then, depending on the rules, there can be gradations. The Swiss rules, they have an explicit provision providing that in exceptional cases, preliminary interim relief orders, meaning interim relief orders that are so urgent that they are called preliminary because they are not the product of party debate, such orders may be granted, but subject to the requirement that upon issuance, the requested party, meaning the defendant, needs to be provided with the application and promptly given the opportunity to be heard. And then, as part of that process, as soon as the other party would be heard, then the preliminary interim relief order could be varied if necessary. The SIAC Arbitration Rules 2025, they also build in a possibility in the context of the EA mechanism, which we will talk about later, to request a preliminary protective order. The practical examples are very rare, but there are some, and interestingly, it's the practice of the Iran-US Claims Tribunal, which, as you know, has given rise to a body of publicly available case law, and which have been adjudicated based on the UNCITRAL 1976 rules. But that body of case law indicates that the IUSCT has accepted to award ex parte measures in very exceptional circumstances. And there are a couple of treaty-based cases based on the 1976 UNCITRAL rules, with one case being Boyko against Ukraine, dated 2017, where the late David Caron was president, who also has obviously ample experience on the IUSCT, and who noted with respect to an application where the applicant was being subject to severe beatings by state authority, was detained in an unknown location, and had put in an emergency application for prompt relief, which in that case was granted, and it was granted before the state had the opportunity to comment. And the justification given in the order was really compellingly drafted. And I'm taking the liberty to read it, to quote it briefly, because it exemplifies and explains why in those very, very narrow cases it can be warranted. So in rare cases, the urgency of the threat to procedural rights and to the preservation of the claimant's underlying rights may outstrip even the speed with which the interim measures may be granted to such instances, and the procedural rules or practice of a number of international courts and tribunals adopt the practice of issuing a form of temporary restraining measure subject to the requested party getting an opportunity to comment. So it is very rare and narrow, but it is a necessary tool, and I would subscribe to that. It is a necessary tool to
Can I just
respect
sort of
the
pick
effectiveness.
up with Sergey for his thoughts on this topic?
Sorry, could you repeat the question? No, sure. So, but I think there are 4 or 5 points, briefly, that could be made here. And my views are quite skeptical of the suitability of ex parte in an arbitration setting. I'll be quite frank here. So first, it is a courtroom remedy that's imported into a consent-based process that rests on party equality and the right to be heard. So those don't mix well, in my view. Second, enforcement is fragile, pretty much non-existent. A preliminary ex parte order is often not really directly enforceable. Interim, that's a different story, right? Third, there is a risk of arbitrator bias subsequently. When you hear just one party without hearing the other, there might be an issue where it's sort of disbalanced in that sense, and it's difficult to unsee a certain submission without hearing the other side, right? Fourth, I think courts are better placed for true secrecy matters, if you wish. If you need stealth or if you need teeth, go to court. 5, a fast ex parte today means slow and complicated and challenged tomorrow. So, I mean, a order that would trigger some form of, measures would then require return hearings, reconsideration by the tribunal, possible court skirmishes. And 6, if ex parte must exist in an arbitration setting, it should have guardrails to make it truly exceptional, impossibility of notice, full and frank disclosure, mandatory one, with real sanctions for omission, that's crucial, security and cross undertakings, and damages as default, that's what courts do, automatic short expiry upon several days of the ex parte measure, and a return hearing. Again, those are the things that courts, of course, do. And orders obviously subject to review by the tribunal. So those are the things.
Just 2 thoughts, following up on this and what happens in practice, in my experience. So the Dubai Arbitration Center's rules, much to my surprise, because I didn't look at this in detail until I saw the first application, has the, or provides for the opportunity to make ex parte applications on interim relief and especially emergency arbitrator applications. As soon as you have it there, it seems to be used. Because of course it's very convenient that you don't have to bother, in quotation marks, with the other side. And so I know that, I don't think emergency arbitrator applications are that frequent, but I'm at least aware of 2 of them filed within DIAC that then, of course, were ex parte because, you get rid of a whole lot of problems, at least from counsel's point of view who makes the application, although I absolutely hear you, Sergey, on issues like enforceability and so on.
And just thinking very practically, Anne, if you're sitting, you're hearing one of these, So you're now privy to unilateral communication from one party to you. You've made whatever order it is that you've made on that as an ex parte application. How do you then bring it back into the arena of making sure that everyone else knows what's going on, what's been shared, so as to make sure there's no confidential information that you have that the other side is not aware of?
I'm not sure, is my short answer. Because, you know, where I see it, it is in emergency arbitrator applications, and we'll come to those, and that's one of the problems I will briefly address. But there you don't really have that issue, at least not as the emergency arbitrator, that you're faced with this, because it's, if I can put it this way, kind of the next arbitrator's problem. Because once the decision is made, you as the emergency arbitrator are out of the picture. If this is possible in interim, in so to speak, normal interim relief applications, I don't know. I guess there needs to be. I haven't had this situation, but I also, here again, Sergey's point of how do you unsee something, where you have to potentially build in a stage of the proceedings where that then is being dealt with, i.e., what I want to call fallout of this application is then being addressed.
Marina.
Yes, I think there is one crucial point, which is that, yes, confidentiality may warrant making a request ex parte in view of obtaining an order. And then, if you do not get the order, meaning the arbitrator refuses to order the relief requested, that refusal needs to be communicated promptly, and it needs to attach the initial application. And conversely, of course, if the order does endorse and adopt and grant the relief requested, then the application will also be attached. But the order is made, and so the interim preliminary obligation is extant. It will remain valid only for a limited period of time, pending, firstly, a potential reconsideration based on the respondent's response, and then, secondly, potentially a re-adjudication on the merits more globally. But what matters is that the request is communicated. Whether it contains confidential information is to that extent not relevant. It cannot be shielded from the other party. And to that extent, the consideration whether to unsee something that has been seen, it's not relevant from the moment where a party requesting an ex parte interim relief makes the choice of putting the information to the arbitrator. It has to assume that the information will be shared. It's just a question of time. So it's only that small time lag. I mean, only, it's easy to say on the concept, but less easy, of course, in practice.
But presumably, every piece of information that you have received in every communication you have had on that ex parte then needs to be shared on an inter partes basis.
Exactly. It promptly gets shared. The other side promptly must be able to comment, and the arbitrator must be prepared to reconsider immediately, if needed, the well-foundedness of that order. I think in practice, and here we come back to this idea of the obvious, if the request and the need to grant such relief is not absolutely obvious, I would expect any arbitrator to refrain from ordering it for reasons that relate to preserving the parties' rights.
I think just as an aside point, it's increasingly easy in practice, I think, for there to be inadvertent unilateral communication between a party and the arbitrator. Who hasn't? Put up your hand in this room if you have never hit reply when you meant to hit reply all. I think we all have done that. Well, maybe some people. Okay. maybe it's an age thing, but certainly I have, but I think most people have. And you're then in a position where you suddenly realize as an arbitrator that you have had information from one party which wasn't copied to the other, or maybe you've done it by mistake. And then what you have to do is exactly the same thing, which is immediately you realize that, put your hand up, explain that's what's happened, and make sure you share everything that has gone on unilaterally by mistake. Anne, you mentioned emergency arbitration, which is going to be our next topic. The first thing is that an emergency arbitration fills a gap. If you're in court, you can always just go to a court. If you're in arbitration, you can't go to an arbitrator until the arbitration has been started and an arbitration tribunal has been constituted and set up, which led to the problem, what happens if you need emergency relief before that main tribunal has been set up. And so emergency arbitration is an attempt to deal with that by allowing an emergency arbitrator to be appointed to deal with something very urgent. And then, as Anne has already indicated, as soon as that has been dealt with, it's handed over to the main tribunal, who's then established, and the emergency arbitrator disappears. Now, I mean, there's no definition of an emergency. I've got two grown-up daughters, one of whom I gave a credit card to when she was a teenager, because her concept of an emergency was, I've been snowed into an airport for 4 days, they've run out of food, I've slept on the floor, can I go to a hotel? My other daughter, I didn't give one to because her definition of an emergency was there's only 3 pairs of boots in the right size left in the shop. But what is an emergency and what are the challenges? And over to you.
I like that. I'll come to you for parenting advice in the break. So, as Julian rightly said, basically, emergency arbitration or arbitrator applications are those for interim relief before the tribunal is established. So essentially, you're facing some of the challenges we've just discussed with regards to emergency, with regards to interim relief at the outset of an arbitration before a tribunal exists. And what I found particularly challenging, having sat as an emergency arbitrator, is, of course, first of all, the time frame. You have, I want to say, no time to make a decision, or to be a bit more precise, you have everything between sort of 5 days and I think 14 days is what I found the most. So the Singapore Arbitration Center rules provide for a decision to be made within 14 days following the transfer of the file to the arbitrator. You have, maybe I should also say that, the advantage that you are only one. So you as an arbitrator do not at least have to try and build consensus between a 3-member tribunal. That helps. But when the file gets to you as an emergency arbitrator, you have, for example, under SIAC, 14 days. You have, under the SCC rules, 5 days, which is really very, very short. And then there are rules, again, for example, the Dubai Arbitration Center gives you a reasonable time frame, but in practice, sort of anything longer than 10 days, I think, is being frowned upon as not being too reasonable anymore in these kind of circumstances. And so when you look at that, of course, that time frame is really very short. And therefore, first of all, I think the foremost challenge is kind of due process. I think, it is of utmost importance to build a timetable at the outset of this very short time frame that manages to come, or manages that, for the parties to make their submissions, feel that they have the right to be heard, and then for the arbitrator to make a decision in that very short time frame. So, and that what needs to be done is that due process is being recognized. I think one of the reasons why, for example, ICSID does not have emergency arbitrator rules in their rules, in their provisions, is that is a concern they have. And now I appreciate that that is a particular animal, because these are investor-state proceedings involving states, and so therefore some of these issues are a bit specific. But I think I'm told that due process concern is one of the reasons why you won't find our emergency arbitrator provisions in the exit rules. And in particular, speaking from experience and not wanting to make this too long of a monologue, is what I find very challenging, and I've had the situation is, and we've touched on this already, if the respondent is not participating. And so I had a very big case where, really, I can tell you this in practice, is you disappear. I mean, for those 6 days I was dealing with this, and this was under the Hong Kong rules, where in theory you have 14 days to render a decision. So when I took the appointment, I thought, 14 days is not too bad. What the Hong Kong Center, who was otherwise spectacular in how of managing this, didn't tell me was that really in practice I needed to make a decision in 6 days because it related to an ongoing court proceeding in the country, that was of relevance, and against which I needed to, or was requested to make an anti-suit injunction. And that court hearing would take place in 6 days. So there is no point in issuing an anti-suit injunction after the hearing has taken place. And so really in practice I had 6 days, and the respondent didn't participate. And so there you are, with what we have touched on already, left with only hearing one party's view on all the issues in terms of urgency, in terms of the imminent harm, etc. And really, frankly, that left me nail-biting. I mean, you disappear for 6 days. My family didn't see me anymore. On one hand, you could argue that a non-participating respondent makes it easier because you gain time, because they don't want to make submissions. But it does actually make it much more difficult in practice, because you are kind of left, I don't want to say guessing, because of course you still make your decision on the basis of submissions and the evidence before you. But I did sit there thinking, what would the respondent have to say on those points? And so in practice, in particular with regards to the due process concern, that makes it difficult. And of course, but that's not a point that's particularly interesting for me as an arbitrator, the enforceability, of course, to me, and Sergey has touched on this, but especially with regards to emergency arbitrator decisions, is something which is challenging.
Sonia, I think you have a point.
I will completely echo what just Anne said, but maybe from the counsel perspective, I think the biggest challenge from counsel and party perspective is having a fair shot to present your case in that compressed pressure of time situation. And just to give a real example, just recently we had a emergency arbitration case, a fintech client, every second counts. Client comes to us on Monday, ICC dispute resolution clause. We had to bring the emergency arbitration application by Wednesday. So that means we had 2 days to comprehend the highly technical case, to collect and organize the evidence and to present it, to draft requests in a way that the emergency arbitrator can make findings on the prima facie case criteria. And all this while making sure you do not write anything prejudicial, because you have 10 days under ICC rules to submit your request for arbitration. And then we had, within 12 days after submission, the hearing, which is a virtual hearing, but still you have to manage with the client a timetable, a schedule, the calendars to prepare for that. And here's the striking part for me, at least. In my experience, emergency arbitrators apply the same evidentiary standard as they do in the standard interim relief procedure. So while you have just days to prepare to make submissions, and you as an arbitrator have days to read and understand the case, you still have the same expectations when it comes to the legal standard and to legal test. And while I heard the last panel and how there was a lot of excitement that there is a first case in Georgia, emergency arbitration, and from Valentina that this is a good efficiency tool, I agree, but I think we have to rethink the process, how it's running, and make sure that we're on the same page on that. Compressing days of preparations, years of preparations to days, and yet having the same bar of proof from the emergency arbitrators can really be burdensome.
Margarita, I don't know if you've got any comments on that before we lead on to enforcement.
Well, I think I can only second what Sonia said. It's very difficult to collect all the evidence, so it would met the same standard applicable to any other applications, basically. And if we may start with the enforcement, it does not make it more easy, to be fair, with all these difficulties when you prepare the application. Then you go again into the enforcement stage, and while preparing the application, that's something you always have in mind. You always think about how you're going to enforce and where you're going to enforce, because it would always depend on the jurisdiction. And each jurisdiction has a different approach to the enforcement. For instance, there are countries like Singapore, which recognize interim awards with the same degree of so to say, award level as any other award. And it would be much easier to recognize an interim award, especially if the tribunal issued this decision in the form of the award in Singapore rather than in other country. For instance, the US, it's also the country where it's much easier to recognize an interim measures award because the US is much more flexible with that. But for instance, in the UK, the country where I work, it's used to be much more difficult compared to a final and binding award, as I mentioned in the New York Convention. And thanks to the recent amendments in the Arbitration Act, which came into force just this 1st of August, now we have emergency arbitration explicitly written in the Arbitration Act. And now this is something which can be enforced easier than it used to be before. But still, I don't recall any mentions of specific interim awards in the new Arbitration Act. So this is another challenge the practitioners face. So it always comes to the jurisdiction which is applicable to that particular dispute. And there are lots of issues which one can say that there was no consent. That means that's why it cannot be enforced. One can say it's not final. It can be reviewed. And I think Anne mentioned that after the emergency arbitrator finishes his or her job, now is the actual tribunal who decides the issue. That means that this interim measures award, including the emergency arbitration, can be overturned. It can be amended, and that doesn't add much of a final value, so to say, and that makes it much more difficult to enforce. And it's especially more difficult in the investor-state arbitration, if we would have time to talk about that later, because it adds completely different angle to that.
I mean, just picking up a couple of points. Firstly, I would be remiss as a Hong Konger not to point out that Hong Kong actually was the first, I think, jurisdiction to specifically amend their legislation to enforce emergency arbitrations.
That is true.
And interestingly, we are tied with Singapore in second place as the most popular seat. And Singapore's done a good job, but Hong Kong is there too. But in terms of, Marina, very, very quickly, because we need to move on to investor state, but the issue in terms of enforcement is often, is it a final award or not? But any thoughts on that? But secondly, what's your experience? Do parties actually comply with interim measures, orders and emergency arbitration decisions, even if they're not technically legally enforceable?
Yes, 2 points for me. One is the typology of the act, and the other is what is the strategic goal pursued. Regarding the typology of the act, it's true that the New York Convention provides for the enforceability of arbitral awards, right? And this is reflected in the bulk of national arbitration laws. Meaning, if you come with a document labeled order of interim relief or whatever order, you may not be able to use that enforcement mechanism, although the tendency seems to be opening up. But arbitration rules, they cater to this situation by giving the tribunal the choice between adopting an order or, making the decision in the form of an order or an award. And that is where also the role of the party comes in, strategically in presenting your request and outlining what are you seeking. Are you seeking an order, or are you seeking a partial award which rules with finality on an interim position? In the construction arbitration context, this comes up frequently with respect to the DAB issue, but I think it's transposable to the general arbitration context. It depends on how you phrase your request for relief. And you can obtain a partial award on a position which is interim and maybe subject to revision. That, I think, is practically feasible. Now, one needs to look at what the strategic aim is in requesting arbitral interim relief and trying to enforce that. Of course, if your aim is to seize the accounts of a given party, a safe option is to go to the courts of that seat. If you are in arbitration, your strategic goal in obtaining interim relief and enforcing that can be much broader, because even though you may not get a certain asset or have a transfer of property right away, you will have secured, at least on an interim basis, a recognition of a right to this happening. If that right is not respected by the defending party, you will have an argument in your favor, and the other party will have to answer in front of the tribunal, which creates an incentive mechanism for spontaneous compliance, if compliance is possible, of course. And so there can be a gray zone, but it can be used strategically. And I think from experience, spontaneous compliance rates are rather high when compliance is possible. Investor-state arbitration is a different case. I think we will get to that. We're waiting all impatiently.
Which is probably a good segue to introduce. Do you want to lead off?
Sure, yes. So investment arbitration and interim measures, or even emergency arbitration for investment matters, quite a fascinating topic. And I've jotted down 8 or 9 thoughts that I had on this. So I'll just run through them in no particular order, and happy to sort of discuss this later on. So first is the source of the powers of the tribunal to order interim measures. And here it's interesting. I mean, if we look at the ICSID Convention, Article 47 tells the tribunal may recommend provisional measures. And it's funny because case law tells you recommend means actually impose, but then the question is, why does the convention, they say, recommend? And if you go back to the drafting of the convention, turns out that the initial drafts of the ICSID Convention actually contained the word prescribe interim measures, but then there was some opposition from certain states as to how can you prescribe, so the agreement was reached that I would say recommend, yet all the case law essentially tells that recommend means something binding, so that's quite, I think, fascinating. Now, the core legal test, similar to commercial arbitration actually, more or less, we've come up in our team when we draft those things with an abbreviation called TRUMP. So time sensitive, rights to preserve, unrepairable harm, that should be irreparable, it's unrepairable harm, merits, reasonable success, and proportionality. So that's your TRUMP. Now,
if only.
The tribunals can protect both procedural rights, integrity of arbitration, preservation of evidence, but also substantive treaty rights. Maintain the status quo is the typical example. And so that's point number 3. Point number 4, the common interim measures, which we've seen both on the claimant side having asked for them and on the respondent side having defended against them, are, as I said, status quo, non-aggravation directions, pretty general terms, document preservation, confidentiality, and information sharing protocols, restraint of steps to undermine the arbitration, so sort of those narrowly worded anti-suit injunctions or whatnot, and historically security for costs, of course, which has recently been introduced formally in the ICSID rules, at least. Now, in terms of the fascinating provisional measures that we've seen, there was a case against Qatar where Qatar imposed a death penalty in absentia against a claimant who managed to flee the country. Now, the claimant sought interim measures. The tribunal declined to order it in the terms that the claimant sought them, but recommended, sought assurances from the state that it would suspend criminal investigations and not take any measures to, well, enforce the death penalty on the guy even though he fled the country. The applications, though, often failed, and that's my point number 5, because they stumble upon urgency or irreparable harm criteria. Compliance is problematic, even though there's one fascinating case. It's a ICC arbitration, Paris seated, but against a state-owned company, so technically as close as an ISDS that you can get, where measures were ordered, non-aggravation of dispute, with an astreinte, so a French mechanism that essentially allows a penalty for non-compliance with the order on interim measures, so 50,000 euros per day. So that was quite fascinating. I'm not sure whether, again, it worked or not, but at least this was ordered. 7, for emergency arbitration, this is quite novel in ISDS. So the test is largely the same, but you have more urgency, of course, that sort of factors in this pattern. The problem is the availability of the measures. ICSID doesn't really say anything about those. ICC expressly excludes, if I recall correctly, emergency arbitration from ISDS matters. SCC permits those, and there are several cases where they have where emergency arbitration has been ordered in ISDS matters. And I think the last point here is that the very idea that emergency arbitration measures or emergency arbitration are used as a tool in ISDS, to me means that claimants start thinking about investment arbitration as a concept earlier. So not after the fact when the business was taken or the bad thing has happened or whatever, and then the lawyers come and say, oh, do you know there's this wonderful thing called investment arbitration? But it seems to be that claimants are more educated now, or so businesses or businessmen are more educated about the very concept of investment arbitration. And from that flows, I think, the tendency to at least try and deploy emergency arbitration when needed.
Thank you. Margarita, I don't know what your thoughts are, and what do people need to know about emergency arbitration interim measures in an investor-state context?
Well, I completely agree to what Sergey has raised. I think these are very, very important points to consider, but maybe just a few things from me. It's very interesting how emergency arbitration, ISDS, it is quite rare, as Sergey noted, but there were a few cases against Moldova, if I remember that correctly, where the tribunal examined what is more important, emergency or the measures or the following the treaty, because the treaty prescribed a cooling off period, and it was not clear what is more important, and the tribunal ruled that the emergency of the measures is more important in that case, because if there are no investment, there is no case, basically. And I think this is fair. And another point which I think is very important, especially in the investor-state arbitration, is that sometimes the urgent measures are required from the state, which is the respondent. And it gets a bit tricky when the claimants, on the one hand, they want to have the proper dispute, obviously, because the procedural efficiency needs to be maintained and everything to enforce everything later. But at the same time, the immediate measures are required, and especially with this Qatari case, where someone's life might be at stake. And while preparing for this panel, I read a survey, I think published by the SCC, what are the most usual types of interim measures requested. And turned out, to my surprise, that the measures involving imprisonment are on the last place, which to me was a bit surprising, because I thought in the investor-state dispute, this might be the issues at stake, and this is something you might think of when you think about disputes with the state. So claimant may be in prison, claimant may face any other judicial penalties. But yeah, I think these would be my takeaways on that. Thank you.
Lilith, I'm very much in your hands. We've got 10 minutes in our session for questions, but it also delays lunch. So we're happy to deal with questions now, or if you'd rather, we can take questions over lunch.
Right now, if anyone has questions from the
Okay, other than why are we not having lunch? Does anyone have any questions? Or are there any thoughts on the panel that we haven't covered that it would be helpful to share? In that case, I think it sounds like, oh, hang on, we have got a question.
I would just like to share Amka's experience on
ex parte request for interim measures. So we had one experience with the ex parte request, and what our arbitral tribunal did, he didn't examine the request ex parte. He just wrote to the requesting party that the other party has to be notified as well. Afterwards, the discussion will be held. So basically, we haven't had any case of ex parte request on interim measures.
Otherwise, in which case it just shows that arbitration can be very, very time efficient and get you to